All right. Hello. Welcome back. Those of you who are going to watch live again, I was on for an hour and I'm back again. So if you're still watching now, that's awesome. So a viewer requested in my normal live stream that started at 12:30. I do 12:30 to whenever. Today it was an hour. Requested that I talk about Price v. Chicago, which was a case that was supposed to go before the Supreme Court, and the Supreme Court refused to hear it. Now, what's interesting is I heard almost nothing about this. I'm really surprised that this wasn't made, a bigger deal wasn't made of this in the circles that I'm in, the news that I listen to. I don't know if I just wasn't paying attention back when, because this was last year that the Supreme Court turned it down, refused to hear it. Let's see, because the article that I linked in the description is it's from July. So no, this was this year. So it must have just been that it was July and there were so many things going on. And I was so focused on COVID that I didn't hear about this. So anyway, so I guess the case started in 2019. That's why it's Price v. Chicago 2019, but it was turned down by the Supreme Court in July. And you know what it was is I was so much worried about the June medical case. I was thinking about that, and this slipped right past me. So, and it's because the Supreme Court didn't actually give an opinion on it. They just kind of kicked it back to the lower courts and let the lower court and the existing precedent whatever stand, and they just didn't consider it. So they didn't rule or give an opinion either way on this case. But let's just break down the case real quick. So in Chicago and Harrisburg. So Harrisburg, Pennsylvania. So Chicago, Illinois, and Harrisburg, Pennsylvania. Both have these 8-foot bubble zone laws. And so to do this justice, first we got to talk about abortion facilities, pro-life protest, and sidewalk advocacy. So since Roe v. Wade, since abortion was legalized, and probably before Roe v. Wade, where it was legalized in certain states, pro-lifers have gathered outside of abortion facilities with various different strategies, but the overall understanding that children are being killed inside that building over there on Saturday morning or Tuesday morning or whenever it happens to be for that particular facility. We're going to go out there and do something. So there's been all kinds of different somethings that pro-lifers have done over the decades to say, okay, we can't just ignore this. We have to address the fact that children are being killed inside that facility. So, for a long time, there was a lot of protesting, and I am of the opinion, and I know there's going to be pro-lifers who disagree with me, who follow me, and there's pro-lifers who I am great friends with and have worked with and have done activism with who disagree with me on this. But I am of the opinion that the abortion facility is not a place for protest. Okay, hear me out. So you're like, well, wait, there's babies being killed. Yes. Protest puts pressure on people and it raises awareness. So you protest when you need to let people know that there's an issue going on. You need the public to be aware. And when you need to put pressure on somebody. So now I can understand that impulse to protest because you want to put pressure on the abortion facility to close. However, that doesn't tend to work so well. Because here's the thing is everybody at the abortion facility is acutely aware of what is happening. They may be denying it to themselves, they may be lying to themselves, but they're acutely aware. And the woman who is going in for an abortion is under a lot of pressure. We do not need to add more. So I love to see abortion-related protests, pro-life protests in front of Capitol buildings, downtown, college campuses, neighborhood, like just out in the public square where people aren't thinking about abortion, where it's in the back of their mind or not on their mind at all, and they're going about their day and they're not thinking about the fact that babies are being killed. That's where I want to see protest with signs and chants and raising awareness, right? And putting pressure on politicians, maybe on businesses that are supporting the abortion industry. But here's why I don't like it outside the abortion facility itself, because outside the abortion facility, you have this high tension situation already without any pro-lifers showing up. Even if the pro-lifers all stay home, it's still a high tension environment. You have young women and middle-aged women. It's not just teenagers who get abortions. It's pretty much anybody within reproductive age. It's the whole spectrum. You have women who are going in for an abortion because they believe it's their only choice or they believe it's the best choice for them. Very, very few women, almost none, go into an abortion facility happy that they're exercising their reproductive freedom. And the vast majority of those women know that it's a baby and know that abortion will kill that baby. But they feel they have no choice, or they feel like this is the best out of all available options. Sometimes it's the baby's not going to have a good life, and this is the best thing I can do is to not make them live through whatever I would, they'd be subjected to in life. So there's all kinds of rationalizations, but the majority of women who have abortions rationalize it because I'm not ready for a baby. I can't do this right now. This is gonna, it's too complicated, and I'll have a baby sometime in the future. Not ready yet. A lot of women are like, someday down the road. But they're thinking about that baby, and they're thinking about themselves, and they're thinking about their situation. And the protest doesn't invite them to air out those ideas. So what we want in front of an abortion facility is to get the woman talking and listen to her and get her talking about what is going on in her life that brought her to this point. What is happening that you are here at this point in time about to go into that abortion facility and have that abortion procedure done that will kill your baby? And we don't want to be yelling at her. We don't want to be condemning her. We don't want to be insulting her. We don't want to be shaming her. Not that we think that the abortion is okay, but that we want to listen to her and we want to understand what brought her here so that we understand how to help her. So, what you want is an approach where women who are going into the abortion facility feel safe and comfortable talking to you before they go in, because once they go in, it is so hard to get them out. It is so hard because the abortion facility, the abortion industry is so good at keeping them in once they're in. Okay. Once they're in, that's happened. Women have gone in and come back out and chosen life. It happens, but it is difficult. It is much easier to convince her to leave before she goes in. So the more that you can make yourself as a pro-lifer, you're a pro-lifer out on the sidewalk, the more you can make yourself approachable and inviting and a welcoming person to talk to, the better. And the more likely you are to convince her to leave that abortion facility and not go through with that abortion. So, but there are groups that take a different approach and have some level of success. It's arguable how much success they truly have. But we know from former abortion facility employees, such as Abby Johnson and others, that when groups are protesting and yelling and have signs like babies are murdered here and that sort of thing, we know that women go running into the abortion facility because they are scared or intimidated, or even just weirded out. They're like, oh, those people are weird. I don't want to talk to them. When we are approachable, when we are kind, when we are loving, when we are compassionate, and when we have signs that direct the woman to safe help, right? Safe resources that are not going to be a threat to her and her baby. So for instance, I'll have a sign that says, ask me about free pregnancy tests and sonograms, because I want to offer her free resources that are going to help her and her baby and direct her away from the abortion facility. So that we want to target those signs. I'll also have a sign that says, that the facility that I do sidewalk advocacy outside of, that it the sign will say that this facility has failed its health inspections. The sign I have has the name of the facility on it because there's multiple facilities or there's multiple offices in that complex, and we don't want to confuse people. So specifically the name of the abortion facility has failed their health inspections. The other side of the sign says has failed to uh, properly sanitize instruments, which is true. We have their failed health inspection. They failed to properly sanitize their instruments. So I go out there and I participate in 40 Days for Life, which is an awesome organization. And 40 Days for Life and other pro-life groups actually filed amicus briefs on this case, this Price v. Chicago case relating to these bubble zones. So let me circle back around to that. So basically, there are pro-lifers who protest. There are pro-lifers who do sidewalk advocacy. There's lots of different things that pro-lifers do out on the sidewalk. I'm a fan of sidewalk advocacy and prayer vigils like 40 Days for Life does. There's other approaches, and I understand why people go for those other approaches. I have not seen that to be the most effective or the best use of our time and resources out on the sidewalk. The best use of that opportunity. We have this opportunity on the sidewalk to reach these women in those last moments before they go through with that decision. And just looking at that opportunity, how do we best use that? But regardless of why you're out on the sidewalk, or even if you're doing Operation Rescue style, so up until the 80s or 90s, I think it was up until the 90s, pro-lifers went out and did rescues where you got a whole bunch of pro-lifers to come out and literally block the abortion facility, block the doors, block the driveways. Nobody's getting in here. And the whole idea is that if nobody can get in the building, then no abortions are happening today. And to some extent, it worked. Abortion facilities closed permanently because they did enough rescues. And pro-lifers would be arrested, but they would be arrested. It was trespassing. You'd pay a fine. Maybe you'd fight the fine in court, but most likely you just pay the fine. And there was fundraising to pay the fines for people, and then you'd get released the next day or a day later or whatever. Then they did the FACE Act, which made blocking the entrance to the driveway or blocking the entrance to the building illegal for abortion facilities or for clinics. I think they said medical clinics, but specifically abortion facilities and churches. So churches are included in that. You can't block churches. It's a good thing to know. So anyway, so there's been all kinds of reasons people have gone out there. And so the FACE Act was the first real like hard restriction on pro-life protesting and pro-life activism outside of abortion facilities. And there's a lot of pro-lifers honestly, that if we could repeal the FACE Act, we would see a very different pro-life movement. Like they would be out there because the FACE Act basically made it a felony and 10 years in prison. And so that made it a lot less practical to do these large scale rescues. Because you're going to end up with a lot of pro-lifers in prison for 10 years and not out doing activism. So that was a problem. But there's definitely a movement within the pro-life movement, like kind of a sub-movement of let's bring back the rescues in some way, shape, or form. There's Red Rose rescues, which are interesting. It's an interesting concept to me. I'm interested just to see the success rates with it, but it's an interesting concept. I'm like, okay, that works. You're still risking arrest, but it's, like if that's effective, if you save babies that way, then great. And you're willing to risk that, go for it. But specifically with sidewalk advocacy and prayer vigils, we're out on the sidewalk, we're out in the public right of way, which is free speech. And there's no good, justification for banning free speech on a public right of way just because it happens to be outside of an abortion facility, And so the McCullen v. Coakley case back in 2014, the Supreme Court struck down a Massachusetts law that established a 35-foot buffer zone around the abortion facility. So you could not do any protesting or any protest activities, and that included sidewalk advocacy, within 35 feet of the building. Or of the entrance, I believe. It's 35 feet of the entrance. And so that was a huge problem because then you couldn't do sidewalk advocacy, even peaceful sidewalk advocacy where you're offering resources, you're talking to women, trying to direct them away. You couldn't do that. You couldn't come close enough to the entrance, even on the public right of way, because that was the problem. Was it's one thing to say, oh, you can't come on private property, which they all do. You can't come on my private property, and we get that. They have that right. They don't have the right to kill children, but they do have the right to keep us off their property. They don't have the right to kick us off the public right of way, as long as we are not blocking the right of way, and we are so that passersby, pedestrians and bicyclists should be able to go by, and that we're not, endangering anybody. We're not harassing people. We're reaching out in love and compassion and offering resources. So that was a buffer zone. So that established the static area where you couldn't protest. And the Supreme Court ruled that that was an unreasonable infringement on First Amendment rights. Now, my issue here, of course, as I've talked about before, is that the Supreme Court should not be striking down state laws, even state laws I disagree with. So at the time I celebrated the McClellan-Coakley case, I was actually outside the Supreme Court when it came down. I was working with Students for Life of America at that time, and I was out there with them. We were rallying, we were celebrating, and we got this case in our favor. Now looking back, I'm like, okay, it's, I have problems with the way that went because it struck down. Again, it's this idea that the Supreme Court can strike down state laws, and that's how Roe v. Wade happened. If the Supreme Court can strike down state laws, then Roe v. Wade stays. But if the Supreme Court cannot strike down state laws, then McClellan v. Coakley goes. Right? So we got to kind of be consistent here. So what needs to happen in these cases where the state or the city puts an undue restriction on your freedom of speech, freedom to protest, freedom to assemble, it needs to go through the state courts and the state Supreme Court according to the state constitution. So not your First Amendment right, because that's federal. First Amendment is federal. The federal government cannot restrict your First Amendment rights. States have their own free speech clauses in their constitutions. Some states have a Declaration of Rights in their constitution. Others have a Bill of Rights, or there's some list in every state constitution of the rights of the people. And thank you, Kevin, for jumping on. And so if you look back, I did a video a couple months ago on nullifying Roe v. Wade. And in this, and I talked about how the Supreme Court in the Constitution is given very specific authority. And it specifically is given authority to intervene in cases between multiple states. It's Article 3, and it goes into there, but it's when it goes beyond just a single state and their laws. And the whole idea is that states are bound by state constitutions. So Massachusetts is bound by a Massachusetts constitution. Illinois is bound by an Illinois constitution, right? There's arguments for states being bound by the federal constitution, but I don't like that. And a lot of pro-constitution people are concerned about that because that gives the federal government way too much power over the states. Federal government was established to, for the states to be able to work together, but the states are still supposed to have sovereignty over their own laws, right? So really, the federal government should not be getting involved in individual. Now, that will mean that in some cases, it's like, oh, we have this law and it's not right. That our state passed this law and it's not right. We need to be working through the state level Supreme Court and the state constitution. So the state constitution contains usually the same list of rights that are in our Bill of Rights, in our First, Second, Third Amendment, and so on. The state constitutions usually have a very similar or identical list of rights. And state laws that violate those rights need to be struck down by state Supreme Courts. What that does is it gives states the autonomy to do things like ban abortion. So the whole basis of Roe v. Wade was the idea that the federal government could strike down a Texas abortion law because it violated because they decided that it violated the 14th Amendment. It didn't. Their arguments were bad, But in the court's mind at the time, the Texas abortion law violated the 14th Amendment and therefore was unconstitutional. So when we give the Supreme Court, when we give the federal government veto power on state laws, we end up with 47 years of legalized abortion. And if we don't recognize that the federal government does not actually have that authority in the Constitution, and the states stand up and say, no, enough, we're not going to let you prevent us from protecting our own citizens, then, we're going to have, it's like we need to stand up and say that this is enough, that this is not okay. Jurisprudence developed together. So, yeah, and I really recommend, Kevin, that you take a look at the 10th Amendment Center, because they've done a lot of work on this, and Michael Bolden from the 10th Amendment Center knows much more about this than I do, and I really love listening to his takes on these things. But there are different, so, the idea that jurisprudence has developed to give that power, that's a problem. The Supreme Court should not be gaining power. The federal government should not be gaining power over time. The Constitution has enumerated powers that are given to the federal government, and all the other powers, all the other authority that is not enumerated in the Constitution is reserved to the states and the people. That includes criminal law. So I understand that I understand Kevin doesn't like this. And I know you requested the video. I know you don't like what I'm saying on this, but so I understand that it sounds very simplistic, but the Constitution is supposed to be simple. Our government was supposed to be much simpler than it is. It has become complicated because we've allowed the federal government to gain inch by inch. That you give them an inch, they take a mile. All this extra power that has put us in this situation where the federal government runs our lives, and the federal government is the one that's preventing us from saving babies. The federal government is the one that's saying that Texas can't regulate abortion clinics, or Louisiana can't regulate abortion clinics. And when we give the federal government that power, we have to understand that they are going to abuse it. The more power you give any branch of government or any level of government, the more they will abuse it. And so we really need to shift our focus away from this idea that the Supreme Court is not going to save us. The Supreme Court is not going to fix all our problems for us and overturn itself. And so this is the thing in the McCullen v. Coakley case and in this Chicago case. There's a precedent from 2000 where the Supreme Court ruled that yes, they can do these bubble zones. And so just to make sure I'm clear on the bubble zone law in Chicago, specifically it's an 8-foot zone. You cannot come in within 8 feet of a woman who's going into the facility without her permission, or anybody who's going into the facility or exiting the facility without their permission. Now, they shouldn't have to make that law. It's a bad ordinance. They shouldn't be restricting it like that. It's awful. But at the same time, as a sidewalk advocate, I would not come within 8 feet of somebody. I'm glad you're enjoying the video. Good. Okay. I know. I'm just like, I know I have unpopular opinions sometimes, but anyway, so I wouldn't come within 8 feet of somebody that I was sidewalk counseling without their permission in general, because that's personal space. I mean, maybe 8 feet, maybe 6 feet. Hey, for COVID, 6 feet. But like if I'm talking to somebody, I'm not going to go right up in their face without their permission. And the permission can just be like, yeah, I'll talk to you, like they're willing to talk to me. Okay, I can come a little closer. So the way that the ordinance is written, like it's still like, I don't like the fact that they wrote that ordinance, but at the same time, I feel like it's something that sidewalk advocates, depending on how it's being enforced, I feel like something you can work around. I don't know if you're in Chicago and doing this, or if you're just watching this from somewhere else, but it's something that you can work around, and it's something that needs to be fought in the state Supreme Courts. I'm very much a states' rights, state autonomy person, and I've been, especially in the last few months, I've really been talking a lot about how we need to nullify federal programs and nullify Roe v. Wade. and not depending on the federal government to save us, and not depending on the federal government to fix its own errors, and give up power that it has taken. When the federal government takes power, it doesn't give it back. And so that's where the states have to stand up and say, we're going to take this power back. We're not going to take this to the federal courts. We're not going to take this to the circuit courts anymore. We're going to deal with these issues in our own states with our state Supreme Court, with our state constitution. So that's the thing, is the Massachusetts law that was struck down on McCollum v. Coakley, the Illinois or the Chicago ordinance was, that was struck, or that wasn't struck down, that is upheld. The Chicago ordinance, the Harrisburg ordinance, those are all violations of those state constitutions. And so within the state, you can go to that state, to those state courts, and sue there and get the state Supreme Court to strike it down. And that's a much more constitutional way to go about it, rather than saying, hey, federal government, please come and overrule my state. Because the problem is, once you invite the federal government, please come overrule my state laws, you've invited them in. It's like a vampire. Okay, the federal government is like a vampire. Once you invite them in, they can enter, and then they can do all kinds of craziness once you let them in. And now we've long since invited the federal government in to strike down state laws. But specifically, every time we invite them in again, because we say, well, on this one, this is my issue that I care about, and so I want the federal government in on this. But every time we do that, we're inviting them in, and they're sucking us dry, right? It's a vampire. And so and I talked about this with the Montana case. So back in June, I think. So back in June, there was the Montana case, and there was a religious freedom case about funding. It was some funding program where it was a school choice kind of program where it was funding to go to religious schools. It was some way of raising money for scholarships for private schools. And it was a Montana, and the Montana Supreme Court struck it down, I believe, and then it went up to the U.S. Supreme Court, and the U.S. Supreme Court overruled the Montana Supreme Court, and actually overruled the Montana state constitution. So here was the issue with that case. And if you go back, you can go back and watch that video. But the issue was that the Montana Constitution specifically said that the state could not fund religious organizations like a private Christian school. Like it had specific language in the Constitution that you could not use taxpayer funds to support the private school. So my argument there, even though the Supreme Court ruled, I enjoy private school. Like, I went to private school. I think private school is great. I understood where the Montana State Supreme Court was coming from, because the state constitution was pretty clear on the issue, and they were being consistent with the state constitution. So then the issue is, okay, if your state constitution is bad, if your state constitution has stuff in it that you don't like, there's an amendment process. Every state has a constitution, and they have an amendment process. And so that's where we need to focus our efforts, is in some cases amending our state constitutions if they don't protect our free speech rights adequately, or if they don't protect the preborn adequately. And this goes back into nullifying Roe v. Wade. We need our state constitutions to protect vulnerable human beings in the womb. And if we can do that, and then we pass laws, or we have laws already on the books that are consistent with that constitution, and we say, you know what, the Supreme Court never had the authority to strike this down. It's our law that we passed in accordance with our state constitution. We're going to enforce it. And you go back, and I've talked about this in my video about nullifying Roe v. Wade, and 10th Amendment Center has talked about this. You go back and look at the Fugitive Slave Acts, and where the federal government said, we're going to do, we're going to have this law that you have to turn it, if somebody's a runaway slave from the South and they make it to a northern state, a free state, you have to turn them back. You have to send them back south. And the federal government said you had to do that, and the state said no. And they passed laws essentially prohibiting that, and stopping those escaped, formerly enslaved people, the people who had escaped and were now free, preventing them from being taken back to the South and defending them in court. And so, and then you look at, we had Supreme Court rulings that, said that segregation was okay. We had Supreme Court rulings that said that slavery was okay and that, enslaved people were property and all of that. And when we have those bad rulings, it is imperative that the states stand up and nullify them and refuse them, and that we reject the idea that the Supreme Court can make law, right? So, and that the Supreme Court can strike down a state law because they want to, because they decided that they read some weird interpretation into the 14th Amendment. And so obviously there's a lot of things wrong with Roe v. Wade, but when I'm saying that the basic premise that we need to go back to is the idea that the Supreme Court was not given authority in Article 3 of the Constitution. Like, it does not have enumerated powers that allow it to strike down state laws that are in accordance with state constitution and that are limited to the state. So if a state passed a law that impacted the state next door, well, then you might have an issue. Then you could bring the Supreme Court in to settle the disagreement. But if I pass a state law here, yeah, and bad rulings do exist at all levels, absolutely. And that's why we have limited government, or we're supposed to have limited government. We don't currently, but that's why we're supposed to have limited government according to our Constitution. That's why the federal government has limited power, limited enumerated powers in the Constitution, limited role, and is not supposed to be involved in every aspect of our lives because government is corrupt at its very core. And so by having levels of government that are responsible for specific issues and keeping everybody in their own lane, federal government stays in its lane, state government stays in its lane, we stay in our lanes, and then you limit the influence of one level or one branch or one office. Like, you limit their influence over everything. So the federal government right now has its hands in everything because we've let them. We've let them control everything. And so now we're going to them and asking permission. Please let us Sidewalk Council, federal government. Please let us go offer help to women. We're asking them for permission, and we shouldn't be. So I do think that yes, I know I've gotten off track. Well, but it all comes back around to the Price v. Chicago case and comes back to the Chicago and Harrisburg ordinances that, that those ordinances are bad and they should be stopped. They should be overturned. And so the people in Chicago or the people in Illinois, because there are conservatives and pro-life people in Illinois. I know they exist, right? But they need to organize, they need to mobilize, and they need to say, you know what, we're not going to put up with this. And first of all, the sidewalk advocates need to be out on the sidewalks in Chicago. The way the ordinance appears to be written, and I don't know how it's being enforced, still allows you to do sidewalk advocacy. And then if they're actually enforcing it the way it's written, and they actually arrest somebody because they supposedly came within 8 feet of somebody, while they were sidewalk counseling or whatever, that's when we need to challenge that and say, no, you shouldn't be able to arrest me for my free speech or my free speech rights according to the Illinois state constitution. It needs to go up through the Illinois courts to the Illinois state Supreme Court, and same thing in Pennsylvania. And I understand that there's a lot of liberals and pro-choice people in both of those states. And that's where we need to educate and organize and get activism going and help people understand that even if you're pro-choice, even if you think abortion's okay, we should not be limiting people's free speech rights, and I should be able to walk up to somebody and have a conversation with them. Now, I should not be able to get in their face and harass them and invade their personal space without their permission. That's just a politeness thing. But my point is that these bad ordinances and these bad laws need to be handled at a state level. And that if the state refuses to, essentially take care of this issue, then it needs to be an issue of organizing, mobilizing. And that's when you get protests. That's when we go protest, we go demonstrate, and we vote, right? That's when you're like, okay, we're going to vote we're going to organize, we're going to vote these city council people out of office, or we're going to, whoever we need to vote out of office, whoever we need to change, so that we can get things back on track. And it's a mobilization thing, it's an activism thing, and I think that in general, people in general, pro-life movement, conservative, libertarian, all these different groups of people need to start taking our focus away from the federal government. We need to stop paying so much attention to them and go and actually focus on the local level. Okay, Kevin says, I think you should actually go to an abortion clinic with pro-life advocates as someone who has their polite and respectful. No, absolutely. I was there this morning. No, they are absolutely pro-life and respectful. I'm not arguing otherwise. I'm a sidewalk advocate. I've been one since 2013. I was there for an hour and a half this morning. And I participate in 40 Days for Life. I'm a trained sidewalk advocate with the Central Texas Coalition for Life here in Austin. And so that's what I'm saying, is that the vast majority of pro-life advocates, sidewalk advocates, are absolutely polite, respectful, and compassionate. I'd like to believe I am. But my point is, I've seen those who aren't. Yeah. So, and I've had a couple of success stories over the years. My very first success story with Sidewalk Advocacy was the first. It was one of the first times I really went out on the sidewalk on my own. Like, I'd kind of done training and stuff, but it was the first time I was really on my own, and it was in California, of all places, Orange County, California, outside of Planned Parenthood. And I was out there, and I had a sign from from Silent No More Awareness, and it said, "Women do regret abortion." And I was holding that sign, or I had that sign propped up next to me, and a woman drives in. She's a young woman, maybe in her early 20s, not much older than me at the time. Um, and I kind of waved to her, but I didn't, I chickened out, and I didn't say anything as she walked in. And I was just kicking myself. Oh man, was I kicking myself, because I didn't say anything. I didn't do what I was trained to do. And I was just like, I just let her walk into that place. She walked out 5 minutes later, got in her car, drove up, and rolled down her window and said, I couldn't go through it. I saw your sign and I couldn't go through with it. And I gave her information at that point. Then my training kicked in, and I gave her information, and she drove off. So that's just to say that, a lot of times we don't realize when we're being successful, because we don't always see it. And I was so thankful that she stopped and said something. But there are a lot of women who choose life and say, I had an abortion appointment. I went there. I saw people praying outside, or somebody tried to talk to me, and I ignored them. I didn't talk to them. But because they were out there, I changed my mind and I walked away. So even if you're going out there and doing sidewalk advocacy, that's awesome. I'm glad you are. And so, I'm glad you're doing that. And if you feel like, oh, I'm not being successful, or I haven't actually, saved any babies, you might even not know it. At the Coalition for Life that I volunteer with, we've had several cases where women have come up and or emailed us, or written letters, or talked to us in person, and said, like, 2 years ago, I had an abortion appointment, and I saw you guys out there, and I changed my mind, and I never told anybody. And here's my baby in the back seat. Here's a picture of my baby. So we know that women change their minds because of sidewalk advocacy, even when they don't tell us. And so we need to acknowledge that, okay, we're sometimes more effective than we realize. So no, I absolutely love sidewalk advocacy, and I've worked with a lot of different pro-life groups that have a lot of different approaches to activism outside the abortion facility and what that should look like. Um, so for Price v. Chicago, the basic idea here is that the Supreme Court refused to hear it. They it was brought up to the Supreme Court. The lower courts had said, no, this bubble zone ordinance stays in place. Supreme Court says, we're not going to take it up. So it let the lower court ruling stand. And essentially that case is dead unless they kind of come at it from another angle and appeal again. But otherwise, that particular case is kind of dead, which is why I'm saying that the next step is to go to the state Supreme Court, and really should have been the first step. I don't know if maybe they did, not that I saw, but that really needs to go through the state Supreme Court, according to the Illinois and Pennsylvania state constitutions and their guarantees of free speech rights. So yeah, I mean, essentially that the ordinance is this 8-foot bubble zone, can't come within 8 feet. And that's where I got off on the whole thing about how I wouldn't see myself going in within 8 feet of somebody without their permission, just as best practice. So I don't know if there was something that was happening at abortion facilities in those two cities where that was an issue. But I think it's just them trying to discourage people. And because the way the ordinance is written, it wouldn't, like what I'm saying is that ordinance would not prevent me. Like if I went to Chicago, which I actually have family up in that area. So if I would happen to be visiting family up there and I decided to go sidewalk counseling while I was there, I would be able to go and do what I do as a sidewalk advocate, without violating that ordinance. Like it wouldn't prevent me from doing what I do as an advocate. So I guess that's that's where it feels like a scare tactic more than anything. Like it feels like that this ordinance is meant to scare advocates away and make them think that they can't go to the sidewalk or that they're prevented from going to the sidewalk. And it is an undue restriction. It is an undue burden. I'll use that term. Undue. It is an undue burden on your free speech rights, right? Like which are actual constitutional rights, both state constitutional and U.S. constitutional rights, unlike abortion, which is not a constitutional right anywhere. But we do have actual free speech rights, and this ordinance does place an undue burden. I'm just saying it, like, as a sidewalk advocate, I would still be out there doing sidewalk advocacy. And most of the time, as a sidewalk advocate, I am trying to encourage the woman to come to me rather than me going to her. Now, the issue would be on enforcement. I could see it if it was a downtown abortion facility and you're standing on the sidewalk. So if it's one of those where you have to park down the street, or there's not necessarily a parking lot right there, and you have to walk up, and so there's a public right of way, and the sidewalk advocate can be standing on that public right of way really close to the facility entrance, and so everybody has to walk past the advocate, which is awesome. I would love to do sidewalk advocacy at a place like that. Most of the ones that I've been at have like a big parking lot, and so you can't be in the parking lot, so you're like way back away from the entrance, and you can't actually be right there, and so nobody has to walk past you to get in. So anyway, so I could see that. And then if they were going to try and enforce it where you're standing outside on the public right of way and a woman is walking past you, but the way the ordinance is written, you have to intentionally come within 8 feet of her as she's walking past. Like, so if you're standing stationary outside the abortion facility, if you're here, you're standing stationary and she's walking past you, that doesn't violate the ordinance. So I'm not saying it's a good ordinance. It's a bad ordinance. I'm just saying that I think it's more of a scare tactic than anything. I don't think it's actually able to stop anybody from doing normal sidewalk advocacy. I just think it's something meant to scare people or make people think that they're violating the law when they're really not. They're not even violating the ordinance by doing normal sidewalk advocacy. Because you would still be able to stand there and she'd be able to walk past you and you'd be able to talk to her because she's coming within 8 feet of you. So it's a bad case, or it's a bad law, it's bad ordinance. I'm just saying, like, I can understand why the Supreme Court didn't take it up because, I mean, well, their reasons for not taking it up were probably not good, but the fact that they didn't take it up is actually consistent with the idea that they don't have authority there. Now, they should overturn their precedent from 2000 that, like, they shouldn't even be having an opinion on this. It's not their jurisdiction as a court. Like, they don't have jurisdiction over those laws or especially city ordinances. The Supreme Court should not have this jurisdiction over city ordinance at all. And it really should be a state Supreme Court issue going forward. So to those pro-lifers in Chicago and in Harrisburg who are frustrated and upset that the Supreme Court didn't take up the case, I just, I kind of want them to think about if they haven't already. Maybe they already have, maybe they're already in the process or they've already tried it. But I just want people to think about going through the state Supreme Court and really approaching it from this, hey, this is an undue restriction on my free speech rights. And also just doing sidewalk advocacy and seeing if they're going to enforce it. Because there's a lot of stupid laws and ordinances on the books in everywhere that are not enforced. It's like, are you actually coming out and checking to see if is somebody coming out with a measuring tape that's stretched out to 8 feet and coming around and measuring whether I'm 8 feet away? And now we're in COVID time, so it's 6 feet, so it's like, am I 6 feet away and whatever? Because if they're not enforcing it, then I think the best strategy for pro-lifers is literally just to keep doing sidewalk advocacy and not changing their approach at all necessarily. And then if somebody comes out and tries to harass them based on this ordinance, then you go challenge it through the state system and say, hey, I'm doing peaceful sidewalk advocacy. You take video of peaceful sidewalk advocacy to show this is what I'm doing and this is what you arrested me for. There's nothing wrong with this. And you approach it that way. So that's my thoughts on it. I just look at the case and I'm just kind of like, okay, well, this isn't something I want. Like, I don't like inviting the Supreme Court or the federal government in to these issues. Like, I don't like inviting them in where they don't have constitutional enumerated power. And it's worth looking at Article 3 of the U.S. Constitution and seeing what their actual enumerated powers are. And just because, and it's the Marbury versus Madison case, I think, that is the one that basically says, oh, the Supreme Court can change what's constitutional and what's not. And that's a problem. Like, just because the Supreme Court says something is or is not constitutional doesn't mean that's true. So, like, that's not, they can't really do that. So, all right. So, I don't know. Anybody have any more questions on that case? Or, I mean, I feel like I kind of went through it. I mean, I'm not a constitutional scholar or a legal scholar. I'm learning a lot about the Constitution and its original intent and its original language. 10th Amendment Center, again, is a great resource. They go way more in depth and they cite all their sources, and here's all the Federalist Papers, and here's what the founders said when they were ratifying and in the debates and all these things. And it really has opened my eyes a lot to how far beyond its bounds our federal government has gotten, and how I would really like to see the federal government be shrunk in size, and that the only way that that's going to happen is states standing up against it. So that's with Roe v. Wade. And I think it's also with the pro-life movement recognizing that this really does need to be a state by state issue. Abortion in general, and even these kind of ordinances, need to be state by state, and mobilizing within states and really those state level and local level pro-life organizations, saying, okay, we're going to focus on what's happening at our state, and we're going to mobilize people within our state to show up and testify in front of our state legislature, to file amicus briefs with our state Supreme Court, and just really getting people involved at the local level, because we're so concerned about what's happening at the federal level. And really, it's these local ordinances. It needs to be mobilization in Chicago and Harrisburg to say, hey, we're going to vote out those people, Yeah, and well, I understand. Yeah, so I can see where you're saying it's a losing argument, and yeah, I'm not going to convince enough people, but just because I don't think I'm going to convince everybody, or that I'm going to single-handedly change our system, doesn't mean that I still think this is the right way to go, even if nobody else agrees with me. So that's kind of where I'm at. But I do think nullification is a way to go. Yeah, but that's the thing. It's not in the Constitution. So yeah, Ken says, although it's not in the Constitution, it's been a part of the Supreme Court from the beginning, talking about judicial review. Um, I don't think that was, just because it's been around for a long time doesn't mean it's right. And I really think we need to say these are the enumerated powers of the Constitution, or in the Constitution, the enumerated powers that the federal government has, and we can't continue allowing them to take more and more ground. That Marbury versus Madison case gave the Supreme Court more power than what was in the Constitution. And that's the thing is, our Constitution was written and ratified and all of that, and immediately people who were otherwise, pro liberty, pro, freedom, pro limited government, immediately started grabbing more power. John Adams is a great example of this. He was so pro liberty, so anti big government, such a small government person. All this very fiery stuff that he said about liberty. And then he becomes president and does the Alien and Sedition Act, which was totally violation of all kinds of rights. But it's from the very beginning of our country, government has tried to grab more and more power. We established a limited government, but government by its nature grabs more power as it goes. And so immediately from the very beginning, that government started trying to grab more power. Yeah, well, and there were founding fathers who argued for that more power, but that's not what was ratified, and that's the point. Is there were debates before ratification, but the states ratified the Constitution and said, "Here's what we agree on." And yeah, we're gonna have debates back and forth, but this is what we ratified. This is what we said. This is our binding, document here. Our guiding our this is binding. They gave it force of law over the government. They gave this Constitution authority. And there were founding fathers who wanted bigger government, but they lost that. And I'm not saying that they all agreed. And again, 10th Amendment Center does talk about that a lot, about the different founding fathers. And even the most pro-government founding fathers would have been considered libertarians today, and small government people today. But the thing is, the ones who are more pro-government, more pro-centralization, they're the ones who chipped away at those protections that we had. And you gain just a little bit here and a little bit there and a little bit there, and it grows exponentially over time. And so the whole thing, sorry, that was their understanding upon ratification. So the argument can be used intended power. Well, so it was those founding fathers' understanding upon ratification, but was it the understanding of the states? And that's where, again, 10th Amendment Center, Michael Bolden talks about how, based on the debates and based on what was the understanding at the time when the Constitution was ratified by the various states, by the several states, that the understanding was these were the enumerated powers. I understand where you're coming from here, but I just really think that we need to get back to those enumerated powers. And the problem is that you give that judicial review power, and now all of a sudden the Supreme Court can strike down marriage laws in different states, which again, federal government has no authority over. Can strike down abortion laws. We got the gay marriage legalization. We got the abortion legalization. We got all these things. And legalization isn't even the right word. It's not that the government legalized it. It's that the government struck down state laws because we gave them the power to do so. We said, you can strike down our state laws if you think that they're unconstitutional, and what you say goes. You get the final authority. The whole concept that we gave the federal government final authority over states, that's where we lose our liberty. Because we can have conservative justices or liberal justices, but ultimately, it's over time, they're more likely to gain power than to give it up. The federal government is not good at giving up power. And so that's my point, is I want us to stop running to the Supreme Court when we feel that our rights have been violated. I want us to start going to our local governments first and working through our local governments first. And maybe there's an argument to be made that if you've worked through the local government, you've gone to the state Supreme Court, and you still didn't get what you wanted, or your rights are still being violated, then there's maybe an argument to going to the federal level. But even then, honestly, I think it needs to be at the state level. And we need to get back to the idea of the several states, right, and state sovereignty. That America was never supposed to be one giant monolithic entity. And that was the whole point for the revolutionaries, was that, the British Empire was too big. The British Empire was too big, and there was a parliament over in London, or over in England, that was ruling over all these colonies that were far away, and that the powers that be did not understand the people. And that we need to, like, that we can't have this kind of big government that uh that rules over all these little places, that there needs to be more local rule and local sovereignty. And that was the whole idea of America. And so the idea that the Supreme Court, the federal government, has power over all these city ordinances, it goes back to what the founding fathers were against. So even though I don't like the city ordinance, I just don't want to go down that road. And I see your comment. Certainly, but shouldn't we go to God first, understand the reasoning behind the case, and argue the intricacies of error? Yes, and we should obey God rather than men. And that's why I said in my earlier live stream is, as Christians, and so that's kind of, going to the theological sense of it. As Christians, we understand that there are going to be times where what we believe and what we know is right comes into conflict with what government says, and that we put God first and we obey God rather than men. And that's my thing, is like, even if you had, like, let's say the buffer zone. Let's say the buffer zone rule in Massachusetts. You know, I I'd like to say that I would go and do sidewalk advocacy anyway, even if it was illegal and even if I get arrested for it. I I hope I would, but that would be a point where we as Christians would say, you know what, we're gonna obey God rather than men, and we're gonna go there. So, and I don't think government is ever our remedy. So your next comment was, my disagreement with you is that you think a form of government should be our remedy, and that your disagreement with me is similar. So I don't think government is ever a remedy, and that's why I want limited government. I think that's the point, is that no government is ever going to save us. No federal government is ever going to save us. No state government is truly going to save us. We have to establish ourselves. We have to kind of fight for our rights ourselves, but we should do those through systems that are available to us, in a way that doesn't give the government more power. And that's my point, is I don't want to give the government more power. Given the argument you're making, the fact that judicial review has been well established. I mean, so we can focus on the errors in the law. My problem is that, again, based on this idea of precedent and judicial review and all of this, I think there's a lot of resistance, even among conservative justices, to doing things like overturning Roe v. Wade. And I just don't think that we are going to see. I would love it. I would love it if Amy Coney Barrett gets confirmed and the first abortion case that comes up, we overturn Roe v. Wade. I just don't think it's going to happen. And I think if we keep on this cycle, we've been doing this for a long time, we're like, well, if we just get the right Supreme Court justices in and we just get them to make the right decisions, we'll fix these problems. It's not going to happen, and it needs to be started at a local level, with people standing up, talking to their their local elected officials. And again, that goes back to the founding of the revolution and the founding of America, was the idea that you need to be able to go talk to your elected official. You need to be able to go to their office, right? And if their office is in DC, or if their office is in London, you can't just walk into their office and talk to them. And so when we keep it at a local level, then if I don't like the ordinance, I can go talk to them. I can make an appointment. Now in COVID times it's different, but I can go make an appointment with my city council official, or I can call them up on the phone, or I can introduce myself to them as their constituent. I can take them out to lunch and talk to them about my issues. When we keep it at a local level, as soon as we give the federal government more authority, we lose that control and we lose that involvement in our system. So I understand what you're saying. It's basically the, like, well, it's too late. It's too well established. But that's what they're saying about abortion. They're saying it's settled law. They're saying it's settled. Yeah, I'm glad we got to have this debate too. So you're saying Amy Coney Barrett concurred with Price v. Chicago. Yeah, and I understand that. I'm saying I don't agree with any. I don't think I agree with any politician or judge or justice or probably anybody on every single issue. But there are people who are overall better and overall, you know, worse. And so that's why I said I would prefer, I don't know, I mean, I guess I don't know what Allison Jones Rushing would say on this, but I do like her better currently. But I know that Amy Coney Barrett's probably going to be the nominee, and I'd much rather have her than anybody that Biden picks. I just think that even Amy Coney Barrett, as much as I like her and I probably agree with her on most things, I don't think she should have final authority over state laws. You know, I just don't think any federal government body should have final authority over state laws, and that's where I'm at. So, well, thank you for suggesting this, Kevin, and thank you for kind of having this back and forth with me. I'm hoping that the live chat replays. I know sometimes it doesn't replay. I'm hoping it does so that people can see the conversation that we had, because I know I'm kind of like reading your comments and then responding to them. But I'm glad we got to talk about this, and feel free to follow up if you have other stuff. But I do highly recommend that you watch the Path to Liberty live streams from the 10th Amendment Center, and go back because they've done a lot of stuff on the Supreme Court on supremacy clause and judicial review and stare decisis, all those things. And it's really worth looking into, and the history of it. So, and because I used to think more along the lines that you are, I celebrated McCullen Coakley. I celebrated Hobby Lobby. Hobby Lobby was a good case. I celebrated McCullen Coakley. I celebrated all these other cases. And I really truly believed that the Supreme Court had final authority. I've changed my position on that just in the last few months. So I'm still learning, but again, 10th Amendment Center, great resource. And those of you who are watching this later, thank y'all for watching this little kind of, all over the place thing about sidewalk advocacy and all that stuff. Again, I'll probably do some more videos either today or this weekend and put those out on some other stuff. But thank you, everybody. And thank you, Kevin. And y'all have a great, wonderful day.